Welcome to today's webinar, Victimisation in Work and Discrimination Arising from Disability. My name's Kit Grayson, I'm associate in the employment team, and myself and Medina Saki will be presenting today's webinar. Can I have the next slide, please? So we will pick up from where we left off in our last webinar in our disability series, and we'll look at discrimination arising from a disability. We'll consider some practical case studies. We'll then look at victimization and again apply that to some case studies. And we'll close by looking at the potential remedies available to a successful claimant in a disability discrimination claim and practical advice for an employer to manage the situation moving forward. Next slide, please. Before we get into looking at victimization and discrimination arising from a disability, hopefully the reminder on the screen is not new to you and it's been picked up from our previous series. However, it's worth refreshing our memory because, of course, these tests are relevant to the Section 15 claim. So a disability is defined as a physical or mental impairment that has a substantial and long-term negative effect on your ability to do normal daily activities. As we considered in our previous webinar on the definition of disability, this is a very low threshold. And so we often find it is the case that a claimant will successfully show that they had some form of physical or mental impairment that satisfies a Section 6 definition. Equally, on knowledge, an employer will be considered to have knowledge of the disability, whether it's actual or constructive. So actual means they are aware of it quite obviously. For example, an employee uses a wheelchair, it's obvious that they have a mobility disability, and so the employer will have actual knowledge. Constructive knowledge is less clear cut. So if an employee has dyslexia, and the employer is not made aware of this, but there is sufficient evidence from considering their pattern behavior for repeated spelling mistakes or typographic errors in their work, then it might display that they have dyslexia, and you have to think a bit harder, and the tribunal might interpret the employer has constructive knowledge of the disability without it ever being confirmed. Can I have the next slide, please? So firstly, we'll be looking at the discrimination arising from a disability. This is sometimes referred to simply as a Section 15 claim, and to be honest, it is almost forgotten about by quite a lot of claimants. This is because it's less clear cut. So if we look at the legal definition on the screen, a person A discriminates against a disabled person B if A treats B unfavorably because of something arising in consequence of B's disability, and A cannot show that the treatment is a proportionate means of achieving a legitimate aim. That test won't apply if A can show that A did not know and could not reasonably have been expected to know that B had the disability. And the reason I think this claim is sometimes forgotten about is because with direct disability discrimination, the issue is obvious. An employee feels they have been treated less favorably because of their protected characteristic of disability. For example, a job applicant is not given a role, and in the reasoning for not being given a role, their disability is cited and the employer couldn't accommodate them. So that might be an example of a direct discrimination. Whereas a Section 15 claim is less overt. It says that the conduct is not directly because of the disability, but because of something arising from that disability. Can I have the next slide, please? And so to consider this Section 15 claim, The tribunal will look at a two-stage test. Firstly, did the claimant's disability cause, have the consequence of, or result in something? You then turn to the second element. Did the employer treat the claimant unfavorably because of that something? And so that goes back to what I was saying just then, which is it's different to direct disability discrimination because we are not looking at direct conduct, but the something arising from the disability. Knowledge is a potential defense to this claim. So an employer is not going to be liable for a Section 15 claim unless it knew or should have known about the claimant's disability. So if the employer has no knowledge, then of course the something arising could not have been unfavorable treatment necessarily. However, it is not necessary for an employer to be aware that the something arises in consequence of the employee's disability for it to be liable under Section 15 if it treats the employee unfavorably because of that something. Come, next slide, please. So what does the claimant need to show to succeed in a Section 15 claim? So firstly, they need to show unfavorable treatment. And if we look at the EHRC code, it gives us some guidance on what unfavorable treatment might mean. And it says, must have been put at a disadvantage. What you need to think is you don't need to look into detailed case law. You don't need to even necessarily think about the EHRC code. You just need to think with common sense. Has that disabled employee been put at a disadvantage? The code also goes on to say, the courts have found that a detriment, a similar concept, is something that a reasonable person would complain about, so an unjustified sense of grievance would not qualify. So there is some assistance for employers where a claimant is raising things that become too unreasonable, that may not be fairly regarded as a detriment. However, I should stress that applying this common sense approach, there is a relatively low threshold. For example, an employee who has a disability, which means she has to work in a different part of the building to her team, on paper, this might not seem as an obvious disadvantage. She can come into work, she can do the same hours, she's still got the same opportunity for promotion and support. However, not being able to work with her team may fairly be regarded as a disadvantage. By not being able to speak to her team, it reduces her opportunity to manage and have contact with them. And so what might seem like a minor inconvenience may actually be regarded as unfavorable treatment. The something arising. So unfavorable treatment must be because of something that arises in consequence of the employee's disability. The obvious example is sickness absence. So an employer taking action on an employee's sickness absence, if that absence is linked to a disability, then the Section 15 claim isn't saying whatever action you took was directly because of the disability. It's not saying, for example, if dismissal was the decision, it's not saying directly because of disability you discriminate against them. It's saying, no, this individual has a disability. That disability has meant they are absent from work for a large period of time. And because of that absence, you have taken the action, i.e. dismissal. And that's where the Section 15 claim comes in. And that's why I say it's potentially one of the more forgotten claims. Cav, next slide, please. However, there is a further defense. So there is a defense in effect that if you don't have knowledge, but also an employer may be able to show that the unfavorable treatment in question must be a proportionate means of achieving a legitimate aim. To be proportionate, the unfavorable treatment has to be both an appropriate means of achieving the legitimate aim and a reasonably necessary means of doing so. Now, if we take the example of sickness absence, if this objective justification defense wasn't available, then in effect, a basic interpretation of the law would mean every time you dismissed an employee for sickness absence connected to a disability, that you would be discriminating against them under Section 15. However, if you have put in place measures to support that employee, increase trigger absences, given reasonable adjustments, but you can't bring that employee back to work, and so they are still absent for long periods, then dismissing them may be regarded as a proportionate means of achieving the legitimate aim of operating your service. Because if you simply do not have that employee in, you might not have to recruit for that vacancy. Cav, next slide, please. So some examples of situations where we might see a Section 15 claim come up. So if an employee has an inability to work unaided, a need for regular rest breaks or toilet breaks, restricted diet, slower typing speeds, regular hospital appointments, difficulties in using public transport, a need for specialist computer equipment, and a need for private and/or quiet working. So if you look at all of these things, there's no mention of the actual disability. What we're looking at is that something arising from. And so each of these elements might be linked to a disability. And so if we take one of these examples, slower typing speeds. If you've got a secretary that has a disability that means she types slower, then if the employer puts her through a performance improvement plan because she's not meeting deadlines because of her slower typing speeds, then it might be shown that the employer has submitted her to less favourable treatment, i.e. the performance improvement plan, because of the slower typing speed, there's something arising from her disability. And so it would shift to the employer to say, okay, do we have knowledge of her disability? If yes, was this a proportionate means of achieving a legitimate aim? How else could that situation could be better managed? Can I have next slide, please? So some advice I would give to employers when thinking about this is it comes down to managers, I would say. So managers should be trained to think more broadly about why an employee may be struggling. If an employee doesn't explicitly tell a manager they have a disability, then to be honest, that quite often is the end of the conversation. The manager is busy and they simply see an underperforming employee. However, because of this risk of a Section 15 claim, I would encourage you within your organizations to ensure that managers have sufficient training to spot and support employees that may have a disability so that you can minimize the risk of a Section 15 claim. I would also advise managers to clearly record decision-making process and meetings. This is to show a paper trail of why decisions were taken and if support is being given, how it's being enacted. I would also encourage a culture where employees feel able to have a dialogue with their manager about the support required. So quite often an employee might not feel comfortable saying, using the word reasonable adjustment, which in itself is a separate claim that we covered in our last webinar, but there might be a broader conversation there that needs to happen. And the way you can encourage that is by fostering a culture where the employee feels comfortable enough to say to a manager, I might need extra time, or I might need this support. There is a slight blurring of the lines between has there been a failure to make a reasonable adjustment and is there a Section 15 claim, but you just take the specific circumstances. I would also say consider the causation. So is the decision because of a disability or because of something connected to their disability? Um, Often, again, managers might say, okay, I'm not taking this act because you're disabled, it's because you're underperforming. No, you need to encourage managers to recognize actually their sickness absence was caused by the disability. And so you need to think about that when managing them moving forward. Can I have next slide, please? So if you want to put any thoughts in the chat function, please do for this practical case study. So an employer knows that an employee has suffered with periods of anxiety and depression that have meant they have been signed off work with stress from work. The employee has only been employed for 1 year. The employer dismisses the employee following a performance improvement plan where their absence was referred to as one of the reasons they were underperforming. So my question is, can the employee bring a Section 15 claim for their dismissal? Give it a second if anyone wants to say anything chat function. Okay. So I would say that there is a risk of a Section 15 claim here. And that is because anxiety and depression may satisfy the definition of disability under the Equality Act. Um, and it's directly linked that there. Well, actually, the footnote simply says stress at work. However, if the manager thinks more broadly that okay, what's caused this stress at work? This individual is known to have anxiety and depression, and it's very likely that these periods of absence have been caused by that anxiety and depression. And so it may be possible for the employee to run a Section 15 claim in this example. So how else could the employer manage the dismissal? What I would suggest is, again, there needs to be a better dialogue between employee and manager, potentially a referral to occupational health, and also more clearly considering in the performance improvement plan whether what's being requested from the employee to improve, if adjustments have been tailored for their disability, i.e., have you accounted for the disability and anxiety? Can I have next slide, please? So in this case study, the employee is in their probationary period, so assume first 6 months of employment. The employee has dyslexia and ADHD, but has never confirmed this to their employer or indicated clearly that they had these conditions. The employee struggles to focus, misses deadlines, and returns work to their manager with a high level of spelling mistakes. The employee's probation is unsuccessful and she is dismissed. So first question, is there a risk of a Section 15 claim? I would say yes, there is. This is because the specific circumstances might give rise to the manager having constructive knowledge of that employee's disability. For example, struggling to focus and as a result missing deadlines and spelling mistakes may be indicative of the underlying disability of dyslexia and ADHD. And so there is a risk here. However, what I will say is the employee has never mentioned either disability to their manager, and there doesn't seem to be anything clearly indicating this. There just seems to be performance issues. And so it's also possible that the employer could run quite a strong argument that they had no knowledge of her disability. And so it was right to proceed to a dismissal in this case. Second question. So even if the employer had knowledge of disabilities, could they proceed to dismiss? So in this case, I would say yes, they could. They just need to be careful. Just because an employee has a disability does not mean that they are, free from the risk of a dismissal. What the employer needs to be doing is, providing adjustments where possible, refer to occupational health for support, considering whether the performance is linked to that disability. For example, struggling to focus might be connected to having ADHD, or this individual simply might not have been performing in the role. They might not have had a passion for the area and were simply missing basic points. So, Cap, next slide, please. So we've looked at section 15. I'll now hand over to my colleague Medina, who will talk us through victimization, another, in my view, forgotten about claim sometimes.
Thank you, Kit. So good morning, everyone. I'll be introducing today's topic, which is victimization under the Equality Act. So Section 27 of the Act defines victimization as occurring when a person is subjected to a detriment because they've either done a protected act or they're believed to have done or may do a protected act. So this can include things like bringing a discrimination claim, giving evidence in someone else's case, making an allegation of discrimination, or doing anything else under the Equality Act in connection with the rights under the Act. So it's important to note that it does not have to be a formal complaint or even an informal complaint, or supporting someone else can also trigger this protection. So the key element we're looking for here are that the individual did or was believed to have done a protected act, and as a result, they were treated unfairly or suffered a detriment. So this protection applies to all protected characteristics under the Act, and it plays a critical role in making sure that individuals can assert rights without fear or retaliation. Next slide, please. So when we're talking about a protected right under Section 27 of the Equality Act, lists 4 key definitions. Firstly, bringing proceedings under the Equality Act. So this is actually making a claim. This means that in practice, if an individual were to bring a claim for, say, unfair dismissal on its own, that is not a protected act under Section 27 because it's brought under the Employment Rights Act 1996, and not the Equality Act. However, if an employee brings a discrimination claim under the Equality Act, for example, claiming that their dismissal was related to a protected characteristic like disability or race, that would count as bringing proceedings under the Act and therefore would be protected. Another example, a second section, is giving evidence or information in connection with those proceedings, and that applies even if the individual isn't the one who brought the claim. Thirdly, doing anything else in connection with the Equality Act, and it's important to note that this is a catch-all. This could include things like raising concerns informally or supporting a colleague. And finally, alleging that someone has contravened the Act, whether or not that allegation is later proven, is as long as it's made in good faith. So these are all protected acts, and any negative treatment someone receives as a result of doing them may amount to victimization. Next slide, please. So moving on to detriment, to prove victimization, it's not enough to just show that a protected act took place. The person must also have suffered a detriment as a result. So the key question for the tribunal asks here is, if the treatment is of such a kind that a reasonable worker would or may have take a view that in all the circumstances it was to their detriment, and this is an objective test. So it doesn't matter whether the employee means to cause harm or whether the claimant was particularly sensitive in that situation. What matters is whether a reasonable person in that situation might feel disadvantaged, even harmed or unfairly treated. So examples could include they're being denied opportunities, they're being excluded from meetings, or even being given the cold shoulder after supporting a colleague's discrimination claim. Next slide, please. So really in practice, if we were to look at some examples, if you've got a disabled employee on a long-term sickness leave, who's being managed under the sickness absence policy, if they're treated unfairly simply because they've requested support or raised concerns about their condition, how their condition is being handled, that could amount to victimization. If a disabled employee requests reasonable adjustment, like flexible working hours or a specialist equipment to enable them to do their job, and they're then sidelined or even penalized for making that request, this again could amount to victimization. And it's important to note here is the actual request that is the protected act. Another example could include a grievance raised about disability discrimination. And this is another clear example where if an employer reacts negatively, say by withdrawing support or excluding that employee, that's potentially victimization. And finally, if a disabled employee brings a tribunal claim connected to their disability discrimination and the employer treats them less favorably for doing so, for instance, by overlooking them for a promotion, that also falls within victimization under Section 27. Next slide, please. So some key practical advice to consider: always assume all written correspondence, as Kit previously said, will be viewed by the employee or tribunal. Assume all actions will be perceived by the employee as motivated because they've done a protected act. Use common sense and tread cautiously but consistently apply policy. What we often see in practice is that once the claim is being made, internal processes like disciplinary, a grievance process are put on hold to deal with the proceedings. But pausing everything can actually make things worse. It causes delays and confusion. Sorry, and sometimes even more claims. So ensuring you treat the employee naturally and respectfully, regardless of the claim outcome. This could include remaining neutral throughout the process and providing the right level of support. And it's important to avoid changes to the role, their working hours, or any promotion opportunities unless there's clarity on the rationale or they've been agreement with the employee themselves beforehand. And ensuring effective reintegration, such as arranging a mediation and ensuring to maintain confidentiality when conducting internal investigations or processes. Thank you, Kit. Over to you.
Next slide, please. Yeah, thanks for walking us through that, Medina. And before I look at these case studies, I think it's worth mentioning that victimization, in my practice, I often experienced it being used almost as a leverage claim in a way. So, for example, Medina gave one of the examples of if a disabled employee puts in an employment tribunal claim, that is a protected act. And so if that employee remains employed by your organization, they will start to perceive every action taken by the employer as potentially motivated by the fact that they have a live claim against the organization. This makes it very difficult for the employer to manage the employment situation and for me to manage the litigation risk. This is because I won't just be defending the one primary claim, I'll be defending the risk of secondary claims from future acts happening. So every time the employee is not happy with a decision being made, they'll say that decision wasn't made for an objectively justifiable reason. They're saying, no, the only reason you did X is because I've put in a claim against you and it's you're acting almost in reprisal against that. That's often not the case, but it can be difficult to dislodge that perception once the claimant articulates it with the tribunal. So in this case study, a housing officer is informally disciplined by their manager for a mistake that means urgent support isn't provided to a local authority tenant. The employee says that mistake was caused by a lack of focus arising from a period of depression. The employee then submits an employment tribunal claim for disability discrimination, which names their manager as an individual respondent. The employee continues to work, but the manager refuses their annual leave request, does not put them forward for a pay reward at the time, and does not involve them in a new project. So, first question, can the employee submit a second claim for victimization and remain an employee? As discussed earlier, yes, they can. Whilst the practical reality of a current employee bringing a discrimination claim against you and your colleagues, it might seem impossible that they could come into work the next day and everything would be normal. That might be what the perceived reality, but actually, of course, they can do that. And often we have cases where that does happen. So has the manager acted appropriately? It appears from these basic facts that they may have acted inappropriately. This is because, employee puts in tribunal claim, then the manager refuses annual leave, doesn't allow them a pay reward, and doesn't involve them in an interesting new project. That seems, maybe if it was just one isolated incident that could be explained, then perhaps that would be fine. But here we're seeing three different acts of potential unfavorable treatment happening to that individual following the fact they've put in a tribunal claim that names that manager in as an individual respondent. What it will suggest that those acts were motivated because of victimization. Of course, the manager may be able to objectively justify each decision, but they will have to do so clearly. So how would an employer manage this situation? So my advice would be, first thing you would do is you'd swap out the manager. If an employee's raised a claim where it's not just the managers mentioned, but they are an individual respondent, then it's entirely appropriate to swap out the manager for someone else to take the heat out of the situation and to risk the acts discussed here potentially being framed as motivated as an act of victimization. For example, if you have a new manager and they look at the annual leave of the team and they say, well, actually, we're super busy this week and I've already got 2 employees off that week, then of course it's completely fine to refuse that annual leave request. They can objectively justify it. The manager is more independent. And so it's going to be difficult for that employee to argue it's motivated because they've put a claim in. Cav, next slide, please. So in this case study, an employee submits a grievance about disability discrimination. The employee's grievance is not upheld. The employee applies for a different internal role. In the internal interview, the hiring manager asks why she wants to change role, and the employee mentions she submitted a grievance against members of her current team. Subsequently, the hiring manager declines to move the employee to the next stage of the interview process. The hiring manager sends a letter that explains that the employee did not have the requisite skills and experience for the role. So what is the protected act? So it would be when the employee submitted the grievance about disability discrimination, she's doing something, she's raising a grievance connected to the protected characteristic of her disability and saying that the employer has breached the Equality Act. Is the decision by the hiring manager an act of victimization in your opinion? And so in this case, in the interview, the hiring manager wants to find out why she's in this internal interview, why she's moving from her current team to a new team. And so she's asking about the reasons. And the employee mentions that there is an existing grievance, i.e. the protected act. And as a result, this individual is then not even moved through to the next stage of the interview, let alone failed the interview. And so it seems like what the manager might have made that decision because she heard that there's an existing grievance, and if she did so, that would be an act of victimization. However, it is my view that because the hiring manager sent a letter that explains that the employee did not have the requisite skills and experience, they've clearly shown the rationale for their decision-making process. It's not connected to the fact the employee submitted a grievance. It's because of the employee lacked the skills and experience. This case study comes from a recent case that I won, a 9-day discrimination hearing, and actually the tribunal agreed that the hiring manager, it would be natural for them to ask that question about why she was moving teams, and that the hiring manager had explained that the motivation for not putting her through was not connected to that grievance, but was connected to the skills and experience. The reason I use this example is, it shows that whilst you might feel nervous about a certain situation and taking an act that won't be popular with the employee, the tribunals can recognize and agree with you that there's no victimization here. There's no less favorable treatment because of a protected act, but it's simply a business decision that can be justified. Cav, next slide, please. So we're coming to the end of this webinar, and whilst I'm not going to go into the detailed law, it's worth thinking about, well, what is the risk we're talking about? So a quick search on some newspapers for disability discrimination awards, and you can see the headlines on the screen there. For example, a disabled lab worker sacked by the NHS Trust wins 70k payout after claiming she took too many sick days because she had to wait 7 months for an adjustable desk. Now, wider members of the public that don't see this day in, day out, see a headline like that and often will be surprised. £70,000 because she was waiting for an adjustable desk. It sounds like quite a high and sizable award. In particular, the other headline there, female police officer wins 1.1 million. That is a particularly exceptional case, but disability discrimination is definitely the highest area of risk when defending a tribunal claim, because it is just so difficult to get right. And as we're seeing in these headlines, there is a real risk of a sizable award. Cav, next slide, please. So the heads of remedy that would be available include compensation for injury to feelings. So as most people on this call will know, there's 3 bands, lower, middle, and upper. It's very rare for me to see an award which is in the lower band, because a lower band award is effectively for one-off minor act. An employee does not get sent the required adjustable technology for their disability, but there's only a delay of a couple of weeks, then that might be a one-off act. But even that, I'm seeing, may fall in the lower middle band, so above 12,000. And really, where you see years of issues and it's impacted the claimant greatly, as I'm sure they will articulate in their claim and witness evidence, then it starts to move into the higher bands. Interest on that award. So from the act of victimization to the date of the award, interest will collect on it. Compensation for financial losses. So this is often where we'll have the argument in a claim. So the claimant may put increasingly tenuous claims here. And what I mean by that is a claimant may say, but for the discrimination by the employer, I would have been chief executive or a director by now, but because of the discrimination, I've been held back, and so I need the difference in my current salary to that of a chief executive, and potentially that for the next 20 years or so. Now, that's obviously a very tenuous link and it's going to be difficult to argue, and a tribunal may be unlikely to agree. But what you need to think about is there is a real risk that if an employee has been subject to discrimination and they can clearly link the impact on them to the discrimination, then they will be able to get compensation for that. Personal injury, again, we're increasingly seeing this being raised. For example, you might get a discrimination claim where they plead injury to feelings, but they also say that the impact has been so great on them that there's been psychiatric injury, and then that would be a further amount on top of it. A tribunal may also make a declaration or a recommendation, and this is non-financial, and it basically says the organization needs to make a change, for example, improved policy and procedure. Finally, aggravated and exemplary damages. These are quite rarely used and are only used by the tribunal where there's been an aggravation of the claimant's injury and compensation of it itself is insufficient punishment for the respondent's conduct, and it may have acted in oppressive, arbitrary, or unconstitutional action by servants of the government. Again, I'm not going to talk too much about that because it's reserved for the most serious cases and is rarely adopted by the tribunal. But as many of the people on this call are in public sector organisations, the risk of that final sixth award is definitely greater, and you need to be careful. So I think that's the closing remedy slide. Can I have the next slide, please? To close with some key takeaways, this is the fourth webinar in the series, and it might make you feel very nervous about how you manage an employee who has a disability. However, it's worth remembering that simply because there are allegations of discrimination, it does not necessarily mean what you're doing is flawed. And what I mean by that is, of course, an employee with a disability will be pushing for greater reasonable adjustments and support. And you as the employer need to listen to that and accommodate it as the best you can. However, there does come a point where what you as an organization can do is limited and you have done enough. And that's worth remembering. I'd stress that managers must be trained to think more broadly and be proactive in how they manage employees who are underperforming. That comes back to that Section 15 claim discussion. So just because an employee's not told you they've got a disability and they are underperforming, a manager shouldn't just jump the gun and proceed to dismissal or performance improvement plan. They need to think more broadly, okay, what are the reasons for the underperformance, and are those reasons connected to a disability? I would stress to take the emotion out of an employee dispute. So this goes to both victimization and discrimination claims more broadly. Where you've got a current employee, they will obviously be very unhappy. No one wants to put in a grievance or a tribunal claim, and often it is a last resort. If you can try and take the emotion out of it, for example, where does there need to be a line manager switch? Does there need to be a mediation? These are all things to help take the emotion out of a situation. Finally, act consistently and record your actions. Under Section 15, you have the defence of objective justification. And so if you've got a clear paper trail showing exactly why you took those decisions and what was considered in taking those decisions, you'll be able to hold it up to the tribunal and say, no, it's nothing to do with disability. We thought about that and we supported them in this way. And so that's definitely a good defence point. So that brings us to the end of today's webinar. We've moved quite quickly through two fairly tricky disability discrimination elements, Section 15 and victimization. If you have any questions, please let me know or put them in the chat function. Alternatively, feel free to email myself or my colleagues afterwards if there's anything that you would like to ask. Okay. Okay, I'm not seeing too many questions, which means, Cav, next slide, please. So we have one final webinar in our disability series, and I would say it's one that you really shouldn't miss. We're hopefully having a colleague, not a colleague, a barrister from 42 Bedford Row to help discuss litigation tactics and how to defend disability discrimination claims, and also some horizon scanning, looking ahead at what to expect within the disability discrimination area. So definitely one to have in your diaries, and we look forward to announcing our guest speaker shortly. Have the final slide, please. So I just want to thank you for joining the webinar today, and it's good that we've wrapped up with 10 minutes to spare today. So thank you very much.